A woman lost her gun rights in 2008 over writing a bad groceries check. Multiple courts have dismissed her petition to get her Second Amendment rights back, and now she's taking it all the way to the Supreme Court. Hello everyone, and welcome back to the channel. I am a Second Amendment absolutist. I don't believe that the right to self-defense against others or the government is a right granted by a permit or a piece of paper, or where the courts say that you can or cannot do. The Second Amendment is meant to protect you from the government arbitrarily making decisions that turn your natural-born rights into a privilege. I've also talked about how the government does that anyway, many times over, and have mentioned before how the government has decided that any felony, even something as simple as writing a bad check, is grounds for deeming someone a second-class citizen, even if that crime was non-violent in nature and the person has done their time and has had a clean record since. The Prison Policy Initiative estimates that about 19 million Americans have felony records. But according to the Bureau of Justice Statistics, only 4.4% of those federal felonies were violent crimes. On the state level, it's less than a fifth. This is one of those other 90-some-odd% of federal cases in which a woman paid for groceries with a check that bounced, and now, 17 years later, the government is still denying her her right to self-defense. But before I jump into Melinda Vincent's case and how she has become a great example of an upstanding citizen still being punished for something she did almost 20 years earlier, this video is brought to you by the only firm that specializes in self-defense, the Attorneys for Freedom and their Attorneys on Retainer program. Now with AOR, they're not an insurance company, so they don't have the same restrictions as insurance companies. So long as you're part of the program, the only requirement for their services is that you reasonably acted in good faith and that the self-defense incident happened after you purchased coverage. It doesn't matter if you were in a gun-free zone at the time of the incident or even technically a prohibited person like Miss Vincent here. If a self-defense incident happens, you call them up and are instantly talking to a lawyer, not an insurance adjuster, who gives you on-the-spot legal advice and instantly starts working on your case. They cover everything from felonies to misdemeanors, appeals, and even bail bonds, and this year they've added even more, including red flag hits. So switch on over from your existing self-defense coverage by heading on over to my link down in the description and using code LibertyDoll to get $50 off your individual sign-up. Now back to the story at hand. In 2008, Melinda Vincent, at the time homeless and battling a meth addiction, paid for groceries with a check for $498.12. At the time, she had a 7-year-old son that she was trying to feed. She was arrested and charged with bank fraud, but despite facing up to 30 years in federal prison and a $1 million fine, she was granted only a sentence of probation. She completed her probation, got clean, went on to earn 3 university degrees, launching a social work career, and founded the nonprofit Utah Harm Reduction Coalition, which provides therapy to addicts, provides mobile HIV and hepatitis testing, and a needle exchange that also hooks people up with services to get mental health treatment, overdose education, and medical assistance in exchange for those clean needles. She also has a successful podcast called Therapeutic Madness and has been sober for almost 19 years. But because her 2008 conviction could have been punishable by more than a year in prison, she has permanently lost her Second Amendment rights by federal law. That means that she's not allowed to carry for self-defense, even while working in the community with people actively on substances. It means she cannot protect her children as a single mom, or even go hunting with her now 24-year-old son and 16-year-old daughter, something that she says she wants to be able to do. In 2020, she told local Deseret News, "I can't even be in the car with a bullet." The quest for Vincent to get her gun rights back is a long one that started even before Bruin. According to a 2020 report, she was told that she has too many charges to get her records expunged in state court, and there is no expungement law in the federal system, nor do federal courts have the authority to expunge criminal convictions. So she started with going to the Utah Board of Pardons and Parole for a pardon. But short of a presidential pardon, she had no mechanism to regain her rights. Again, short of the only newly announced move of the DOJ taking applications, and so instead she decided to sue the federal government and the state of Utah. In October 2021, a federal judge dismissed her case. She appealed to the 10th Circuit in 2022, citing Bruin. Now, in 2023, the Third Circuit ruled in favor of a man who had been convicted of food stamp fraud in 1995, awarding him his rights back in Range v. Attorney General. But that same year, the 10th Circuit told Vincent that Bruen did not apply to her because it does not apply to felons, that a felon ban is constitutional, and again dismissed her case. She appealed again, this time to the Supreme Court. They vacated the 10th Circuit's ruling and punted it back down in light of United States v. Rahimi, in which they upheld a prosecution for violating a federal ban on gun possession by people with domestic violence restraining orders. Last February, the 10th Circuit again ruled against Vincent, citing Rahimi as proof that the gun ban on nonviolent felons was constitutional. So she's taking it up to the Supreme Court again. Now, the case is in an interesting spot this time around because the Supremes have been denying 2A cases in general, but now we have a split among the circuits. The 4th, 8th, 11th, and now 10th Circuit have all agreed that Bruen does not apply to felons and that the felon in possession ban is constitutional across the board. Meanwhile, the 3rd, 5th, and 6th have all allowed challenges to the law, though the 5th and 6th ultimately rejected those cases. In short, half the courts have said that nonviolent felons are people, and the other half have said, no, actually, felons are not considered part of the people under the Constitution. Vincent is looking for the Supreme Court to weigh in and make the ultimate decision to resolve the split. Her petition notes that the 10th Circuit refused to apply the analysis required under Bruen and Rahimi to her case. According to her petition, under that analysis, text, history, and tradition show that the government cannot permanently disarm Ms. Vincent, a single mother, social worker, adjunct college professor, and nonprofit founder with 2 graduate degrees, solely because of one 17-year-old conviction for passing a bad check. Her lawyers argue that at the time the Second Amendment was ratified, there was no history or tradition of disarming nonviolent offenders. Of course, as I spoke of in the Zerka case last week, some judges would beg to differ. The federal judges in that case cited laws banning blacks, Catholics, and Native Americans from owning guns as proof that the government can and has the right to disarm anyone it considers undesirable without any empirical evidence to prove the person's so-called unsavory nature. And while the court said, well, these days those laws might seem immoral or unconstitutional, they still stand and are a way to uphold this other unconstitutional law. Now, the NRA, Second Amendment Foundation, and Firearms Policy Coalition Action Foundation have all teamed up to file an amicus brief urging SCOTUS to take up Vincent's case. The brief includes some pretty great stuff, noting that Massachusetts pardoned the rebels who attacked government property during Shays' Rebellion, originally telling them that they could have their guns back in 3 years' time, but then gave them back over only 4 months. And records show that the Founding Fathers discussed that the Constitution should never be misconstrued to allow Congress or any government body to disarm any peaceable, non-violent citizen. I would say that that is a pretty good argument for history and tradition. The DOJ's response brief is due July 11th, so we won't have to wait very long to see how this supposed pro-Second Amendment administration responds. Now, I personally have never written a bad check. In fact, I've hardly written any checks at all. But I know millions of Americans have written checks or scheduled payments in hopes that their paychecks would hit before the money was taken out. Sometimes the timing just doesn't work out and people get caught. Does that mean that they should be considered second-class citizens for the rest of their life, especially with a history after the fact like Miss Vincent? Absolutely not. And while some of the people doing that are actual criminals, for the most part, 9 times out of 10, all it means is that person is poor and money is tight. That should not be a damning sentence for the rest of the person's life. All right, ladies and gentlemen, that is it for this video. Please like, share, and subscribe if you are new here. Ring that notification bell. Also, check your subscriptions, check your notifications, and from what I understand is YouTube has changed their algorithms again, so they are no longer necessarily recommending you videos that you are subscribed to. So this is your reminder, if you're seeing this video, to go check out your subscriptions tab every now and then to check out what you've missed. In the meantime, everyone, thanks for tuning in as always. Stay safe out there and happy shooting.